during the pandemic, everyone was really focused on detention and demurrage charges, and that's still playing out now. And I'll just explain this a little bit for our listeners to put some context into your comments and what some of these cases mean and why they're important. Detention and demurrage charges, they're basically place as in principle to keep cargo and equipment moving, with charges applied essentially if you don't pick up your cargo or you don't return the box. I'm simplifying, but more or less. This became such a big issue during the pandemic when many people complained that they'd been hit with huge bills that were simply unfair. And I think I've heard you say previously that detention and demurrage fees were in the billions during at least one of those pandemic years. Maybe you can clarify that number in a moment. But there's a bunch of claims before the FMC right now. We've got claims by lots of different parties, by carriers against railroads, by shippers and truckers against carriers. It's almost like there's a domino effect of legal action up and down the supply chain. And I know you can't exactly comment on ongoing cases, but maybe you can more generally update us in terms of how cases have been judged so far, what sort of levels of refunds or penalties we're looking at. And also, are you going to issue detention and demurrage rules? It's been reported that this might happen as early as June.
Yeah, we're working at, your explanation was completely accurate, and it seemed very simple, but in its implementation, it's very complex. So there's a lot of issues. There was I think it was in 2022, $5.2 billion of detention and demurrage charges that were assessed. So a huge amount. And there is evidence that some of these were charged unfairly when people were trying to return equipment and for purposes related to the operations of a terminal or a shipping line, they weren't either able to get their equipment back or pick up their cargo in a timely way. So our standard is the reasonableness standard, and we've implemented something called the incentive principle. So these charges are intended to incentivize the movement of the cargo, and so we're working through those issues. And we talked about the Ocean Shipping Reform Act. Congress gave us explicit, simplified authority and simplified requirements for the industry to comply on the billing of detention and demurrage, and so we have had a number of cases that, pursuant to what we call the charge complete process, which is on the www.fmc.gov, if anyone's interested, that outlines the process of using this simplified procedure. And so we're going through over 300 cases right now that have been recognized and are capable of being investigated. And a lot, I think, my last report that $1 million had been recovered. There's only been a few cases that have completely been adjudicated, but over 60 of those cases had been settled because the complaints had been brought. So I think we'll see a lot of recovery of penalties and fees that were assessed unfairly. And we're also working on other things. I don't think everyone knows this, but our chairman Maffei ordered an audit of all of the ocean carriers. We're expanding this to the terminals. So we're working with them to assess their process of charging fees. And so my hope is, as time goes on, we'll get to a point where the level of performance on how they assess these is more fair, and they set up a process that will work. But there is a lot of cases going on. And there will be further clarification that will be issued. I'm hopeful this month we'll be submitting a final rule on detention and demurrage assessments. So it is forthcoming. We're in the process of considering comments that have already been submitted by the public. And as a result of our consideration of those comments, issuing a final rule for consideration. So there's some progress, but it's detention, demurrage. It's also really these delays in shipping that cause everything, detention and demurrage and inflation. So we're working through it. I can't get into any specifics on the rulemaking itself because that's under embargo, but I hope that we'll be moving forward on a final rulemaking to clarify that.